And we are back. Over the course of 2022, New York employers saw significant developments in state and local employment laws. Now, this trend continues into 2023 with a wide range of employment laws slated to become effective. So, what are some of the key changes to New York employment laws, and what does this mean for you moving forward? Joining us now to discuss these are the founding partner of the Boyd Law Group, Patrick J. Boyd. And Patrick, glad to have you here, and glad to have you sharing with us, and Happy New Year to you.
Happy 2023 to you as well.
I want to first talk about this here because as we talk about 2023, as I said, the intro, new employment laws, but one law in particular that I am paying attention to, I think a lot of people are paying attention to, is really when you talk about pay transparency. The fact that employers now have to be able to share their salary. Walk us through exactly a little bit more about this law and what we can expect.
Sure. So the general rule is now, and this governs very small employers and large employers, so down to 4 employees or more. The rule is that if you're posting a new job as an employer, you need to post the range of the salary offered with respect to that job. Now, you don't have to be precise. You can give a range, and it just needs to be in good faith. But posting the salary range for people is going to change a lot about how people search for jobs, how they choose what jobs to apply for. And as a result, of course, it will change the resumes that employers are seeing when they open up a job. Potentially equally interesting is the concept that current employees will now get a chance, if their job title is posted, to see what other people in their job title are making. And this may inform them as to whether or not they should ask for a raise, whether or not they're being paid fairly, and things like that. So a meaningful change under the law that I think it's going to take some time to unfold and for us to see and understand all of the implications, but certainly a step towards more honesty and transparency in the workplace and the workplace market.
Yeah, this took place in November, but we know that as it's enacted now, failure to do so. Let's talk about that. Companies that fail to do so, what's the consequence here?
Yeah, penalties can be up to $250,000, which is not insignificant in New York City. In terms of these administrative protocols and new laws, there usually is a fair amount of forgiveness and patience as employers try to implement this policy. But to your point, the law has teeth. So there is going to be a required compliance, and there is a meaningful motivation for compliance with that penalty that you can suffer. $250,000 is a lot of money to pay as a penalty for not posting a job correctly. So employers, beware for sure.
Yeah. I want to move over to the topic of whistleblowers because that was huge. We talked about that last year on the show, but this law has taken effect. What can you tell us about where we are right now and some new developments possibly?
Sure. So yes, this new change to the New York whistleblower law has meaningful extended protections, and I think it really does two, maybe 3 important things. One, which is sort of just a procedural thing, is that employees have a longer time to pursue their claims, 2 years as opposed to 1. Secondly, they have the ability to come forward if they think something unlawful is happening in their workplace and make a complaint and know that they can't be fired for making that complaint. And 3, they don't have to complain about something that they know is done wrong. That is, so long as they have a reasonable belief that something being done is unlawful, they can complain and be protected. That's helpful because otherwise you might imagine a situation where a worker thinks something is going on that is unlawful, but doesn't want to speak up because they know if they're wrong, they could get fired and have no protection. So meaningful change in the law, it brings New York closer to a lot of the protections that were afforded by other states already. So in some ways, New York is catching up on this one, and it's a nice change to see, giving workers a chance to speak out for everybody, the marketplace, themselves, their colleagues, and try to make the workplace more fair, more reasonable, and more lawful.
Coming towards the end of last year, there was an issue that came near to me. Of course, talk about athletes, the name, image, and likeness law that took place in November here in New York. Now, we know the NCAA has a policy with name, image, and likeness, but New York seems to have taken a little stand that's angered some athletes.
Yeah, well, I think the big change is the change you mentioned to start with. That is, after a long period of time, the NCAA has now chosen to recognize that athletes can and should benefit not only with an education, but also with potentially some compensation for contracts that help with where they're getting sponsorships for their name, image, and likeness. I think, and I assume you would agree as a former athlete, that's helpful in the sense that some people have their best athletic experience in college and they don't necessarily go on to play professional sports and make a living then. So if you're a college leader and a college athlete and leader, you have a chance to profit from that to a certain extent, and I think that's important. New York's law or embrace or contemplation of the NCAA rules is slightly interesting to go through as well, and I think this will be interesting to go through in a lot of states. But while athletes can decide to hire lawyers and agents and profit from their name, image, or likeness, there are regulations. They can't do so in a way that's going to violate the team contract. They can't do so in a way that's going to violate the college code of conduct or the like. They can't do things that might undermine the reputation of the institution they're playing for. And there are certainly going to be limitations that I think we're still going to have to see about when and how they can have their sponsorships advertised or promoted, presumably not during classes, presumably not at practice. But what they can do and where is going to be a change, and the law is going to evolve on this subject. I think it's a legal change overall federally that a lot of people are happy with. I think how it's going to be implemented is going to unfold for quite some period of time. We're still going to be learning about it and hearing about it and potentially arguing about it in court as well.
Yeah. Well, let's talk about 2023. We're just at the beginning of it, but there are a lot of cases that we're paying attention to. I do know one, the President's Forgiveness Act. That is still up in question. What other ones can we take a look at? And I want you to elaborate a little bit more about President Biden, Biden versus Nebraska.
Sure. So Biden versus Nebraska has to do with this student debt cancellation, and the Biden put in place an initiative to try to get forgiveness for student debt. There is a meaningful Republican-led claim to challenge that, saying that his act is violating the separation of powers. And we're going to have to see how the court plays this out. If his plan goes into effect, it could cost about $400 billion and forgive about $10,000 in student loan for households making, I think it's less than $125,000 a year. So a meaningful forgiveness of student debt for potentially those families that need it the most. I think we all agree that education is very, very, very expensive on the one hand and very, very important on the other hand. So this is at least one way politically where this current president is trying to recognize that and trim some of the costs associated with the college education. I have 3 kids that are going to be going to college, so I appreciate the fact that the government is trying to address this a little bit. We'll have to see what comes out of it and what the court decides on the subject, of course.
Yeah, I only have a few seconds left, but I do want to get a chance for you to tackle the Paid Family Medical Leave Act. We saw some real significant change starting this year. Let's bring our viewers up to speed with that.
Sure. So New York's law has changed, and probably the biggest definition change is now that the definition of a family member, that is, if you're taking leave and you're taking leave to care for someone, you can now take that leave to care for domestic partners, spouses, children. That was always allowed, but now also siblings, biological siblings, adopted siblings, step siblings as well. The law allows for employees to get 67% of their take-home pay, presuming they've been with an employer a certain amount of time, for 12 weeks. So here the legislature acknowledging the fact that workers may need to take time to care for their families, and that them taking the time to care for their families is something important and something we should support.
Yeah. Well, Patrick, a lot covered here. Certainly we'll have you back. Thank you so much for giving us some insight as to what we should be paying attention to on 2023's legal front. A lot to pay attention to, a lot happening in New York City, and a lot literally happening across the nation. Patrick J. Boyd, thank you so much for being with us, brother.
My pleasure. Happy 2023 again.
Happy 2023 and good to see you. Now, listen, if you want more information, visit Patrick's website at theboydlawgroup.com. We encourage you don't go anywhere. We'll be back with more Open coming up right after this.